lordships and your ladyships leave, may I refer to those throughout hereinafter as the Oakbay respondents.
Thank you, Mr. Poppy.
Thank you, my Lord. I appear for the 10th respondent, VR Laser Services Pty Limited, Jonathan Blow, with my learned friend Ms. Stein and Ms. Sikalala.
Thank you, Mr. Blow.
Please, the court, I appear for the 14th respondent, Sahara Computers, with my learned friends Mr. Luderitz and Mr. President.
May it please the court, together with my learned friends Mr. Badlinda Pereira and Ms. Simon, I appear for Absa Bank Limited, the 15th respondent.
Thank you,
May it
Mr.
please the court, together with my learned friend Mrs. Solana, I appear for the 16th respondent.
Thank you.
May it please the court, I appear for the 17th respondent, that is Standard Bank, together with my learned friend Mr. Mongo.
His surname has become very short.
Excuse me,
His
Lord.
surname has become very short.
It has, we all start with MGC.
Yes.
But the longer version, I'm afraid, is not with us today.
Thank you.
Please the court, I appear for the 18th respondent, that's Nedbank, together with my learned friend Mr. Stubbs.
Thank you.
Please the court, my learned friends Ms. Hoffmeyer, Mr. Lutuli and I appear for the Governor of the Reserve Bank and the Registrar of Banks. That's the 19th and 20th respondents.
Thank you.
May it please the court, I appear on behalf of the 21st respondent, Financial Director of the Bank.
Thank you.
May it please the court, President, I appear for the President as an interested party in the application of the court to be brought by Stanza Bank, here with my learned friend Mr. Lutuli.
Thank you, Mr. Chaskelson. Okay. I think that completes the legal teams appearing before us. The first issue we want to deal with is your issue, Mr. Chaskelson. You are not a party in these proceedings. You have not been joined. You were served with papers.
Not papers.
Oh, you were served? Okay.
We were served an affidavit.
Yes. And you have not applied to intervene.
That is correct.
So how do we deal with your presence here today?
The question, how, if I might take a step back, what has happened is Standard Bank in its affidavit, and maybe before I do that, President, might I ask that I understand that the original copy of the President's the affidavit on behalf of the President is not in the court file. Might I hand that out?
The one signed by Mr. Legabe?
Indeed.
We have it.
But not the original.
Okay. We know why the President has done that. Because of the extended relief sought by Standard Bank.
That is correct.
Now, you don't have to take us there. What we're interested in is, how do we deal with you today? How do you want us to deal with you today?
I would like you to deal with us today, Mr. President, is to dismiss that, strike that extended relief from the roll on the basis of the failure to serve it properly, failure to join the interested parties, and to allow me to leave this court in 5 minutes' time.
You're not a party to the proceedings. How do you ask for such relief? You're not a party to such proceedings. You're not. How do you ask for that relief?
Well, the basis on which the President is here, Judge President, the President could have taken the attitude, I haven't been cited.
Yes.
I will leave it in the hands of the courts and the other respondents, possibly to take the point of non-joinder,
yes,
and trust that no relief that directly affects me will be granted by us.
I think the other Oakbay respondents have taken that point.
Well, my Lord, we weren't served with the papers, so yes, that was never brought to our attention. But my Lord, that would have raised the potential situation where if that eventuality didn't take place, the President would then be faced in a situation where he had to take the attitude publicly that an order that purported to bind him was not binding on him because he was not tasked. And that, with respect, would have been contrary to his duties of promoting the respect for this court.
Yes.
Because he would have been put in, where a private litigant takes the attitude, I wasn't a party, this doesn't bind me, it's one issue. But when the President of the Republic, who is duty-bound to promote respect for the courts and to treat orders as binding, takes that attitude, it is a different story.
Mr. Chastelson, I hear you. You see, the President was given an affidavit, as you say, in December, if I'm not mistaken.
That's correct.
And then this application that brings you here today was filed a day before today.
Well, the affidavit was filed the day before.
Yeah.
What the President sought to achieve was to deal with Standard Bank through their attorneys and point out to them that this plainly was an irregular process.
That
and
has
if
happened.
If they wanted the President to be before court, they should join the President.
Yes.
It was, and then there was a delay between the 7th of February and the 7th of March, where Standard Bank simply refused to commit themselves one way or another in response to the President's letter the State Attorney says. An order won't be binding on the President unless the President is properly joined, either join the President or abandon this relief. When they did reply, Judge President, which was on 8th March, they sent a letter which was ambiguous and which was only clarified on the 15th of March when it was made clear to the State Attorney that what Standard Bank intended to do was to proceed today seeking relief against the President in proceedings to which the President had not been joined.
This is how we see it, Mr. Chastelson. After the President was given the affidavit, a response was sent to Standard Bank to say, follow the rules if you want us to become part of these proceedings. And that didn't happen. That's where we are as a court. And then we were taken by surprise when we saw the affidavit yesterday, which is neither an application to intervene nor a joint application. And our view is, you're not a party before us. The best you could do is to sit and observe. And at some stage, your client may want to make an election, whether it wants to formally join the fray. At this stage, you're not before us.
We're happy not to be before you, Judge President, if the court is happy not to grant relief against us in our absence. I'll quite happily leave the court today on that bill, 5 minutes on that basis.
Well, what relief we grant at the end of the day will depend on what you hear, isn't it? So we can't give you that guarantee or that undertaking now. We haven't heard anything. So you make the election. You want to become party to this? Have you followed the rules? Are you properly before us? If not, then...
We do not want to be party to these proceedings. If Standard Bank wants to issue process against the President, we will deal with Standard Bank's issues when that happens.
Standard Bank will argue when its turn comes why it wants the relief it wants, right? And the matter will stand or fall by what Standard Bank says, because the President hasn't come into the fray.
Well, Judge President, on that basis, we wanted this court to be aware of the correspondence. The court is now aware of the correspondence and the history and of the attitude of the President. That being the case, then the President does not seek to be a party to these proceedings. And if I end up having to observe for 2 days, that's a matter for my client and my instructing attorney to determine.
I think that's a wise decision, Mr. Chastelson.
Thank you.
Thank you very much.
Thank you, Judge President.
Yeah. Is there anyone else who want to say anything after that exchange, or should I move on to the next matter? Yeah. Is it Mr. Blau?
Yes.
You said you may want to say something.
In the light of that exchange, if the matter is going to be dealt with Standard Bank first, I'll deal with it when my turn arrives then.
Thank you.
Thank
you, Mr. Blau. I think that deals with the matter of the interested party, being the President of the Republic of South Africa. We now come to the Rule 7 application that was brought, is it yesterday, if I'm not mistaken?
Yes, my Lord, the actual notice was filed on the 17th. We then received an irregular proceeding notice on Friday, and the application for condemnation was then brought yesterday.
Yes. Mr. Bana, what's the basis of this Rule 7 application, if I may ask?
My Lord, on our side, we've divided the tasks, and my junior, Mr. Premier, will deal with the Rule 7.
Right.
My Lord, the response to your question is very simple.
Yeah.
The Minister, as an organ of state, has had to have taken a decision, or should have taken a decision, to empower the State Attorney to act for them. My Lord, in terms of Rule 7, we are empowered as a party before this court to ask the Minister to produce such authority. That was done on the 17th of March, my Lord, and instead of having an immediate response to that Rule 7 notice, as one might expect in the ordinary course of litigation, instead what occurs is an extraordinary exchange of correspondence between ourselves and the Minister, mostly because of the State Attorney's conduct, owing to the fact that they say they have an inherent power to act and that they don't have to prove, when challenged under the rule, that they have been so instructed. Now, my Lord...
Well, let me just stop you there. We know that the applicant is the Minister of Finance of South Africa. All his affidavits, his application, have happened via the State Attorney's Office. And we're all aware what the State Attorney's Act provides. That's why I'm asking you, what's the basis of this?
My Lord, if I might make three brief submissions in response to your question.
Yes.
The first one is that if your Lordship were to adopt that attitude,
Yes.
the danger would be that your Lordship puts primacy on the identity of the person, the litigant, rather than the issue which is raised. The Rule 7, my Lord, has no regard to who the potential litigant is who has engaged the services of the attorney. It is to make sure that the litigant has properly authorized the attorney in order to appear before this court.
Yeah.
So the danger inherent in my Lord's proposition is that whenever the State Attorney appears before the court, there will be an automatic assumption that the State Attorney is properly here. My Lord, inasmuch as that might be a tempting conclusion, we say that that is not supported both by Rule 7, subparagraph 5, and the State Attorney Act itself. My learned friends, in their purported Rule 30 notice, make reference to Section 3 of the State Attorney Act. My Lord, that section does nothing insofar as authority is concerned. Indeed, the word authority is not even mentioned in the State Attorney Act.
What kind of authority do you want?
My Lord, the court has a discretion to tell us what they want. The State Attorney could either put up an affidavit themselves telling us they've been so instructed, or they could produce a power of attorney.
It need not be in the form of a power of attorney.
My Lord,
the Minister has made an affidavit. The State Attorney is acting on his behalf. And it is a court discretion to have regard to any form which shows that the authority was given to the State Attorney.
He's not acting for himself personally. He's acting qua his position as Minister of Finance. And we know that the State Attorneys is the office set up to conduct litigation for government.
My Lord, in the ordinary circumstances, I think I would be willing to readily agree with you, but the difficulty here, as has been raised in Sahara's supplementary heads of argument, is that in the main application we contend that even though the Minister comes before this court in his ex officio capacity, he is actually here to obtain a different purpose. And as your Lordships will be aware, we go one step further. We say that we want a personal costs order against the Minister and that he must pay for this litigation out of his own pocket and not from the state. The relevance of determining authority, my Lord, is important for us to be able to understand who took the decision, possibly why they took the decision, and what ramifications flow from there. And my Lord, with the greatest of respect, in terms of the rule, we are entitled to do exactly that, and that's exactly what we've done. The danger that the State Attorney has taken in their correspondence with us is to effectively create a carve-out which does not exist in the rules and in terms of the legislation as they exist. And that's an inherent danger. My Lord, I don't want to spend too long on this point because I know that your Lordships probably have more interesting things to hear from my learned friends. But if I might take your Lordships to a response from the State Attorney which is most revealing with respect to how they interpret their
Do you have authority that supports your stance that you can demand such from a government minister to start with, or a state functionary?
My Lord, there is no direct authority on point, but there is authority which suggests that the inherent power interpretation that the State Attorney assumes of its own powers is limited. If I might refer your lordships to the case of Batula versus Minister of Police of Transkei, 1993-4, SA 344, and that's in the Transkei division.
1994?
1993, my lord, volume 4.
Right.
SA 344.
Right.
In the context of discussing the powers of a state attorney for Transkei, the court there found, my lord, that the circumstance that when the state attorney undertakes certain acts, that they may require specific instructions in order to do so, and that they have no inherent or generalized authority that they can. My lord, in this particular circumstance, we say to you that that's even more relevant in circumstances where we've challenged the authority. What we have coming back to us around about the 25th of March is we have a response coming from the minister saying, I beg your pardon, my lord, on the 26th of March, is we saying, notwithstanding the fact that you've challenged the authority of us to be here, we're telling you that we have this inherent authority, we can do whatever we want because we've got the instruction. My lord, the point then is quite simple. If they've been given the power of attorney and we've asked them to produce it, why haven't they done so? And my lord, in those circumstances, we say that the obstructionist tactics adopted by the state attorney, either with or without the instructions of the minister, do deserve the sanction of an adverse cost order.
The JP asked you a question when you rose to your feet to argue, and I think it's a very fundamental question to the issue at hand.
Yes, my lady.
And that issue is, Sahara has been a party to these proceedings right from the beginning. Why is this issue only being raised now? We are aware that Sahara has filed a condonation application, and we know the tried rule that good cause has to be shown for condonation to be granted. The only reason that we've been told of for the late filing of this application is that Sahara has recently changed attorneys.
Yes, my lady.
Is that sufficient to demonstrate good cause for the late filing of this application, given that Sahara has been party to these proceedings right from the beginning?
My lady, you've preempted two of my three answers to your question. The first one is that the change of attorney and change of representation is a fundamental act. It changes the nature in which Sahara is before this court. And in the context of receiving instructions, insofar as the personal costs order, it was drawn to Sahara's attention that authority might be an issue, and that's precipitated the Rule 7. That's the first answer. The second answer, my lady, is that we have brought a condonation application before you, and we advanced the reasons in the founding affidavit as to that. The third point, my lady, very importantly, is that Rule 7 sub Rule 1 itself says that authority may be challenged at any point prior to judgment being given in a matter. So the fact of the matter is that if my lady is not with me, insofar as our preemptive challenge before we arrived here today, or on a more lengthy timeline, then the fact of the matter is that the wording of the rule permits us, when it comes to our attention, to raise the issue before the court. And that is what we've done. And we've invited the minister and the state attorney to prove the authority. But instead of simply filing a power of attorney, instead what we have is obstruction and a concession almost from the state attorney that they actually don't even hold specific instructions with respect to their Rule 30 notice that they've issued. They say that in their letter. If your lordship and my lady would like me to take you there, I can.
Mr. Stein,
Mr. Premad.
Oh, Premad, sorry.
That was my mentor's name, my lord. He'll be very happy.
Oh, okay. Because just remind me, what's your basis for asking for condonation? Is it the change of attorneys or what?
My lord, as I've said in response to my lady, it is that we have changed attorneys.
Right.
We've said, my lord, in paragraph 30 of our founding affidavit, on page 26 of the internal numbering and page 1546 of the record, that Sahara's previous legal representatives did not bring the possibility of disputing that authority to its attention. That was raised afterward. We have come before your lordship. We've come before your lordship to say that we have a right to challenge it in terms of the rule. We've done so. Insofar as we need to seek condemnation from this court, actually, my lord, in terms of Rule 7, the onus doesn't rest on us as the person challenging the authority. The onus actually rests on the state attorney to satisfy the evidentiary.
Are you saying you
burden.
don't need condemnation?
No, my lord, I am saying that we do need condemnation.
Well, I'm still
saying
going
that
back to my first question.
Yes,
What's
my
your
lord.
basis? Changing lawyers? So this is a lawyer's point.
No, my lord, yes and no. Yes, insofar as that is a fundamental act which the court cannot ignore.
What's the other point?
The point is, my lord, is that Sahara was previously not made aware of the fact that it could challenge the authority and that there would be ramifications which flowed from that.
Okay.
And upon the new legal representatives coming on brief, the Rule 7 notice was issued immediately the next day.
Right. Do you have further submissions to make?
Those are my submissions, my lord.
Okay.
You indicated earlier that you're not making a definite submission regarding the form of authority to be filed by the minister. Was that your submission?
Yes, lady, that is my submission.
Now, we all know that the minister is involved in this application in his official capacity, because not only is he cited as such, he has also deposed to the affidavits that were filed on his behalf. Why should this court not accept that involvement of the minister in his official capacity as a deponent to the affidavits as authority
Lady,
for the state attorney to represent him?
Lady, I believe I answered that question already in response to my lord, and that speaks to fundamentally what that would entail. That would say that when a state official is before this court and they are represented by the state attorney, that an automatic assumption must be made in their favor. But we know that the state or organs of state regularly brief private attorneys to appear for them and instruct counsel to argue matters on their behalf. Indeed, I think some of my learned friends might be here under those circumstances. If that kind of situation occurs, it cannot be that my lady's proposition, the logical end of my lady's proposition is that because the instruction emanates from an organ of state, it automatically gives authority to the attorney when they appear before this court and when that challenge is made of them.
Yeah. Now, in this case, the official involved is not a low-ranking official of a government department. He's a political head of the government department. Now, in your proposition, who was meant to give this authority? If you're saying we shouldn't accept his official involvement as the political head of the National Department of Finance, who ought to give this authority?
Milady, I think we might be speaking cross purposes. It's not that someone superior to the Minister of Finance has to give the authority. The Minister could have deposed to an affidavit and said, I've instructed the State Attorney once the Rule 7 came in. The State Attorney must receive some kind of instruction in writing, surely, when they are engaged by an organ of state in order to institute process or defend process before a court. All that could have been tendered to us. Milady, again I raise the point that the danger in having regard to whether the minister is a high-ranking official or a low-ranking official is that Milady reads into the rule qualifications which possibly are not there. And the danger in that, Milady, is that regard then will be had to the nature of the political actor or the interest in the matter or whatever the case is. Of course, Milady, I beg your pardon, we also challenge that the Minister is in fact bringing this matter before you in his ex officio capacity. We say to you in our supplementary heads of argument that that's not true, and if regard is had to the factual matter the factual way in which this matter has unfolded, that interpretation cannot be given to the Minister.